Okay, since we are perfectly on time, we'll start with a panel on reverse engineering and maybe legal problems and things that can happen to reverse engineers and security researchers. I'm Tilo Kirchhoff. I work for Compass Security, and I've got a couple of panelists here with me. It's Diana Nadeborn. She's a lawyer from Berlin, and she's practicing criminal law. So she might be your defender at some point. Then we have Michał Kowalczyk. Sorry. Working on that. Michał Kowalczyk, who has been doing some train hacking, as you might have known, and if you've been in the previous train hacking talk, you have seen one of his slides. And we have Andreas Bogk, who is from Stadler, a company that makes trains, so might be an interesting discussion here. So maybe first we start with Michał, who gives a short introduction on what he has been doing and where he has seen problems with reverse engineering trains.
So, can you hear me? Okay. So, probably you heard about the story, but I will make a short version of it right now. We'll probably discuss it later in more details. We had a case where a train workshop doing like scheduled maintenance on some trains, after doing the service, couldn't start the trains again. And compressing the story, they hired us to analyze the software because they had suspicions that the fault is not random and it's actually intended by the manufacturer. We did reverse engineering of the software, and it turned out that it's indeed like the trains were detecting competitors' workshop because the manufacturer of the train actually lost a public tender for servicing. And it turns out that they programmed the train to fail if the competition tried to service them. And turned out that different trains had slightly different mechanisms for detecting the competitors. But for example, in two of them, we detected just straight GPS coordinates with a list of Polish competitors, like workshops, just by hard-coded GPS coordinates. So after that, we started unlocking the trains because we also found like a manufacturer's backdoor. So if you pressed right buttons in the driver's panel, the trains got suddenly fixed. So we found out the secret code to fix the issue. So we started unlocking the trains, and also at the same time we reported the case to Polish authorities. And the case is still pending. We did a public, so we reported that about a year and a half ago. And after a year, basically nothing happened, so we just went public with the story. That was last December. And after we went public, the authorities actually started working on it. So there's like a very active case in Polish prosecutor's office. And for example, they actually entered the manufacturer's offices in Poland to copy hard drives and documents. That was like 3 weeks ago, I think. And there's also a working group in Polish Parliament which we and also the manufacturer attends. So we discuss with them all the stuff. And of course, they are threatening to sue us, but like they say that since December, but they didn't do anything. They are only like always saying that we are going to sue, but they don't do anything. And also they say that they opened like a second case with the prosecutors. Like they informed prosecutors that we are hacking trains illegally. But they don't, when asked, they don't want to say the number of the case. So we suspect that the case is already dismissed. That's why they don't want to give any details on that. Because this way we would be able to verify if it's still open. And when one of the Polish politicians asked the prosecution, what are the cases, like pending cases about the trains, they listed only the case against the manufacturer. So yeah, that's the short summary.
Thank you. So I'll start with you. So obviously this is in Poland. Germany is slightly different. Could something like that happen here, or how would this be with German law?
Thank you. So in Germany, we actually have pretty strict criminal law when it comes to hacking or IT security. There's a paragraph on data espionage, Ausspielen von Daten in German. And it says whoever gains access to data which was specially protected against unauthorized access will face criminal charges and can be charged with up to 3 years in prison, which never happens, or a fine. And so when the guy who talked about hacking trains before, he said they gained the access, but he didn't push any code on the train. So otherwise he would be in jail. Well, in Germany, it's enough if you just gain the access. So this is pretty strict laws. And but most of the time, when I defend someone, it's usually the manufacturer who has been informed only threatens to file criminal charges. If they do so, it goes to the prosecutor's office, and then probably the case will be closed. And only in very few times there will be a case in court, which is public, so everyone will get information about this. So it's mostly just the experience of very few people involved. And this is why one case in Germany gets a lot of attention right now. It's an ongoing case about Modern Solution. Maybe people from Germany heard about this. So I will summarize this case and what the legal question is here. So Modern Solution, they provide a software and access to a database. The database is on their servers, and the clients can download the software. And there was a client who wasn't happy with the way it worked, or there was some kind of problem, and he hired a security researcher to look into it to find the reason for his problems. So the security researcher also downloaded the software, looked into it, and he found in the source code a standard password hard-coded in the code to establish the connection to the database. And then he used this password, and and he was expecting to access only the data of his client, the one who hired him, but was surprised to see no, he could access data of all of Modern Solutions clients, which is a lot of data, which is you can say a security vulnerability. And he did inform the manufacturer and a blogger at the same time, and the manufacturer didn't respond. And not after a year, after a day, the article was published. So then it's publicly known now. And the manufacturer filed criminal charges against the security researcher. And he was convicted in January this year in Germany for data espionage. And the core problem, the legal problem is that under this German law, the question is, was the data, the database, was it especially protected against unauthorized access? And the defendant says, well, the password, it was in plain text, it was not encrypted or anything. It was for him to see, to find, and to use, so that he didn't hack anything. But the problem is, the benchmark is whether an average person can access in the same way. And the judges, from my experience, say that they are the benchmark. They are the average people with no IT knowledge, which might be fine. Yeah, okay, maybe that is the average. And they say that is undetectable. How could you ever find a password like this? For them, it's They would never be able to find this. So it was specially protected. He hacked it, and now he's been convicted, not for time in prison. He had a 3,000 euro fine, and he appealed. So we will see how this goes on.
Okay, thank you. So yes, so you as a sort of representative of a manufacturer, how do you deal with disclosure, or do you have a disclosure policy or some bug bounty program or something?
We're still working on that. As you have seen, the railway industry is very young. It's just discovering security is an issue. So some of the things that are established in other industries are just coming to us. But the whole topic of reverse engineering is something that actually came up in the current project, right? Because upcoming legislation, NIS2 Directive, Cyber Resilience Act, you probably know about that. They force manufacturers to actually care about vulnerabilities in their software. And so we build trains, right? And we are not building all the hardware in the train ourselves. We buy switches from the open market. We buy PLCs from the open market. We buy embedded computers. Like 95% is components that we buy as a manufacturer. So we are in a position where we need to be able to show that the product, the end product we sell, is secure. So we kind of have the same problem as, the train operator in Poland buying a train from Nevak. They're buying a component for their railway system, and they need to see, how is it behaving? So we're faced with a situation where we as a manufacturer, as an integrator, say we need to look at our suppliers. In theory, we need to do reverse engineering to figure out whether our suppliers are honest with us. Same problem as Nevak and their customers. Is the supplier honest with the customer? And I think we need to look at two different arguments here. Number one, is it legal? Right? Number one, is it morally the right thing to do? And I think we can start with number two, because I think here in the room we understand that the security of a system depends on understanding the security of all the components of your system. And that if you trust the supplier by sending out an Excel sheet, it has 200 questions, and it's like the old US immigration form, you always say yes, right? And then you're compliant, you're ISO compliant, everything's fine, right? And that's not the truth. You need to look at the truth to get the security right. So from a moral point of view, I think we should have the right to do reverse engineering to understand how things work. There might be, exceptions to that, with intellectual properties about algorithms, yada, yada, yada. What can you use the knowledge for that you gain by reverse engineering? So that should be maybe a different discussion, but reverse engineering for security purposes and for verifying the security properties of the components, I think that should be allowed. And now coming to the legal aspect, for the most part, European law is hard to understand because you have so many different national systems. But according to my understanding, we live in a framework where reverse engineering is actually allowed. So to come back to the example, using strings to extract the plain text password from the executable, perfectly fine. The second you use that password to access an API you're not supposed to use, you're in bad shape in Europe. If you're in the Netherlands, for instance, they have a clause in law that, if you circumvent access control systems for a morally justified purpose, you're not being punished. Right? So they have that exception. A security researcher could say, but we're fine. We didn't do any harm and we didn't intend any harm, and they would get away freely. And I think that's a much better approach. German law needs a change there. So summary, from my point of view, reverse engineering should be fine to keep our suppliers honest to us and us honest to our customers.
Just a quick note regarding suppliers. Of course, those logs in Nevak's trains weren't documented. So train operators throughout Poland bought the trains with those hidden features, and they didn't know about them. So, and the only way to learn about them turned out to be reverse engineering, because they actually, before hiring us, they asked the manufacturer what's going on, and the manufacturer was charging them a lot of money to unlock the trains, but didn't want to tell what was happening. So that's also part of the case.
So, and maybe if I can add to the legal aspect. So the good news is for people working in Germany, that there will be changes because the laws in the different member states of the European Union have to be harmonized and also updated. So we expect in October or somewhere in autumn this year for an amendment on the German criminal code that they will have an exception like this. So if the intentions were good, if the gaining access was to improve the IT security of the hardware or software, then the person who did it will not be executed. Prosecuted. No execution in Germany. Will not be prosecuted. We still wait for. Will also be awarded. Oh no, it's all fine. You will be fine. No. So no prosecution, and we still wait for maybe even some kind of award.
Yeah. So there are also, I think we already discussed this before the talk. There will also be some other changes in European law regarding a right to repair, which goes hand in hand, I think, with reverse engineering. And I think that's also something that will be important, that we all have the right to access software or hardware and be able to work on it and get documentation, as you said, is not always available.
Yeah, I think the case in Poland we had is more like right to repair than security. Like they had security issues because of this thing, but like the main aspect is probably right to repair and probably fraud, because they actually were they were selling something different than described. So it's an interesting case. And I hope we will actually influence European right to repair laws because of that case. But we will see.
Okay. Do any of you have questions regarding Yes, I was expecting something like that. I'll go.
Hi. Isn't there a European law that allows you to reverse engineer things for compatibility things, and then as an integrator you are allowed to do that anyway because you need to make the things work together or so?
Yeah, and it works the same in Poland. So we are pretty safe in this case, and probably that's why we still wasn't sued. Weren't. Because like they are only publicly saying that they are going to sue us, but they didn't do anything since 3 months. So probably it's just trying to scare us. And we have a professional lawyer also. So
just a quick question to this: did you ask your lawyer for advice before you did the research, or did you go to him afterwards?
Before publishing everything, and before the research itself, we knew the reverse engineering clause and previous cases, but we did more like consulting before going public.
Yeah, one question regarding, you may have known the initiatives Public Money, Public Code. How is it about, I mainly target Andreas with this question. How is it in trains? Do you use mostly, or would you prefer open source software to solve such problems? Like Michał found in Poland?
So, actually the system that the Selectron PLCs, they contain a lot of open source code. But not completely. There's a Linux running, and next to Linux is real-time operating system kernel, and then there is quite proprietary code for real-time PLC thingy stuff on top of it. So, in my view, open source code, of course, helps, especially with regards to the problems we have with obsolescence management. So, lifetime of products is 30 years. And, I'm struggling. Customers come to us and say, we need security patches throughout the lifetime of the systems. And I say, do you remember what PC you used 30 years ago? Of course, open source software would help there. But as an industry, we're not there for quite a long time.
I have a question about my actual question comes second. So I have a question about the details of the German case that is being rediscussed. So was the security researcher looking at the code that he downloaded, which is available to his customer, and seeing credentials, and then he used those credentials to log in?
Yeah,
that's
correct.
the case, right?
Correct.
Now, isn't this the case that they were disclosing those credentials, and also anyone using that software would have been using those credentials, but probably to using the application, right, only to access their own data. However, those credentials give you access to. It's a weird situation. Is that the case?
Very weird. And to me, the analogy, the parallel would be, so if someone, and people still do that, writes password, Doppelpunkt, 1, 2, 3, 4, 5, 6, 7, and puts it on a sticky note on the monitor. And someone else uses this password, or he said, this is my password to my, I don't know, whatever account. And someone else uses this password, it's not data espionage. So this is where we are in Germany. Okay, this is good. And isn't this the same? Isn't it like a sticky note when it's written in plain text?
Exactly.
But this is how I would argue as a defense lawyer. I'm sure the colleague also did the same. But the judge said, yeah, but for him, this is he would never be able to find this.
And why is okay, so this is a different question, but why is the judge, the judge's lack of knowledge the right measurement when it should be, in my opinion? You know, what's the actual security issue being abused and the actions taken? Which could be taken by anyone, right? In my opinion, because I could teach a monkey or something a bit like that.
I think a novice, we say.
Yeah.
So yeah. So the question is, when is a security measure effective, and who's the benchmark? Someone who has no knowledge at all, or someone who has at least basic knowledge from Googling it, or just but we take someone who has no knowledge about it. And it's a question in criminal law in general, also for fraud issues, not only data espionage. How much is the victim to blame if the victim doesn't protect him or herself at all, and is easy to be lied to in a fraud case? Is the one who did it, he's not liable for it? He still is.
So maybe an issue we should raise here about the whole topic of ethical disclosure of vulnerabilities. So what I think in this case, it's someone who worked in the legitimate interest without attempting harm, and the law is bad, right? I wouldn't even blame the judge for not being able to run strings on a binary. It's just the law that's badly written. However, you also see people who are going around, like, get a mail, hey, did you know that there is a CSRF on your website? And I'm like, yeah, there might be a CSRF on our website, but there is no login to the website. There's nothing you can do with the CSRF. He's writing back, hey, I know, please give me money. And I'm like, why? What for? I found a vulnerability at your site. No, you didn't. There's nothing at risk there. I have 20 more vulnerabilities. I'm going to publish them if you don't pay me. And I'm like, have you looked up the definition of extortion in the dictionary lately? Right. So, there's also something to keep in mind. Sometimes companies don't understand this difference between, someone generally trying to help them and get the situation better. If there's bug bounty program, I mean, it's clear. You give vulnerability, me give money. But there are also people who are not playing by ethical rules when it comes to disclosure.
Just to add one point to this, so for the change of the German criminal law, so the the person, the hacker, shows his the security researcher shows his good intention when he uses the vulnerability disclosure procedure. So this will be mandatory then. But today I already heard 5 people telling me why they didn't use the procedure, although it was in place. But there are so many reasons why not to use it. So we will see if it will be better in the future with the prosecution.
Regarding that German case, would the company actually face any GDPR charges since they have the credentials there in the software? They are allowing for a connection into their system without any IP whitelisting or anything like that. Could that fall under GDPR?
Well, no one's suing them.
What you can do is go to your regional data protection office or the data protection office responsible in that country, in that Bundesland, and tell them they can't act on themselves. Someone has to ask them to do something about that, and then they can go on and impose fines. But it's totally thinkable in a case like that.
And that would make a fine of like 2% of their turnover. So this could work.
And so by suing the researcher, they actually confirmed that the incident happened because they are suing the researcher for accessing the data. So they confirmed that someone from outside accessed the data. So it seems that the case should be simple.
But then it never is.
Well, definitely simpler than your case. So, so any further questions? Yes, there's one.
So with NIS2 coming as a manufacturer, how do you actually implement it? Because your devices obviously are not only in Germany used. Do you follow every single legal standard in Europe for NIS2, or are you just picking the toughest one?
That's a bit of a challenge because European Union said you need to have your laws in place in October, and about half of the countries already said, we won't manage to make it in that deadline. So situation with NIS2 and Cyber Resilience Act is a bit difficult as a manufacturer because we as a manufacturer under NIS2 are not responsible for the security of our products. Very interesting. And we are only responsible for the security of the environment in which we produce the products. So the ISO 27001 part of it, the ISMS, the internal ISMS. However, our customers are responsible under NIS2 for secure operations, and this means that they are supposed to, when they order something from us, to give us, order specifications that helps them to comply to the NIS2 rules, which we then have to implement. Which of course means they have to understand those, and for that the laws need to be in place, which they aren't, and then it takes years between the orders. It's going to be a mess for still a while, right? And what directly affects the security of our products will be the Cyber Resilience Act, but that one will be coming on the EU level in 2025. And then, national implementation in 2026, and then, something actually happening in 2028, so still a while to go. But that would mean, right, you need to make sure that you follow best practices in security, that you ship patches, everything.
And how does it look from the legal point of sight? Like, do you actually, if you have multiple sites in Europe, which one do you actually have to follow then?
For the NIS2, since this is specific to the manufacturing process, wherever your manufacturing plant or your engineering site is, right? So we have to follow like Spanish, German, Polish, Hungarian laws. But then we're also under NIS2 for the service part. And I think we have 54 different service sites, so like 5 or 10 people there servicing trains somewhere. And that's almost all European countries. So yes, it's vital to manage all of that, and we're trying our best to keep track of what the legislation will be. So currently we're aiming for what the EU directive says, trying to establish that as a baseline. And then after that, go up and pick the leftovers, so the additional regulations that some countries place on us. And we hope there won't be too many, but yeah, European law is a mess.
Okay, so it seems we don't have any questions at the moment. Starting with you, Andreas, what are your wishes for the future, for laws, or for what is going to happen?
So I'm very scared about the chilling effect that we've seen for security researchers. Like people here on the stage saying, no, I'm not going to disclose to the manufacturer because he might sue me, right? And that's way too dangerous for me. So this is something that should be shaped, that as a security researcher, if you come with good intentions, that you do not need to be afraid of being sued. Improve that relationship between security research and industry. That's one of my wishes. And the next one would be, I mean, harmonization. We've already gone a long way with the European Union with regards to harmonization. We still have a lot of way before us. It needs to be easier. It needs to be more uniform and consistent, and that would make our lives much easier. And also, reverse engineering needs to be allowed in the interest of everybody.
So, Michał?
So for me, like the same reverse engineering, this should be allowed. If you are owning a device, you should be allowed to check how it works under basically all circumstances. Because like one thing is security and one is like backdoors or hidden features. What else? Probably right to repair. It should be more like clearly stated, and like cases as ours should be completely obvious. Because like the train operators bought the trains, and it turned out that the manufacturer tried to stop them from actually operating them. So this should be like completely clear, and that they are like able to repair them as they want. And maybe also transparency, because the problem there was that when the operators bought the trains, they had basically no tools to analyze what's inside. So the manufacturer of the train didn't provide anything. You had the documentation, but without, it was basically saying where are the engines, stuff like that, but the software was completely undocumented. And additionally, there was no way to check what's actually inside, because one thing is what documentation says and the other is what's actually inside. So it would be nice to like force more transparency into the software which is inside, because there is like already like the manufacturer provides the documentation for the hardware but not for the software.
Thank you. And from the legal perspective, are there anything you...
Well, there was something that I was very happy about last year, that the Ministry of Justice in Germany, they did expert talks on for modernizing the German criminal law, and invited people from the IT security and also lawyers and people who practice or who deal with the law how it is right now, to ask them how to make it better in the future. And this was a nice, a new approach, and it was very constructive talks. And I think there was a lot of new information for the people making the law, or who are in charge, who are obliged by European directives to update the law, that they got from the people from the IT security branch. So that, I hope my wish for the future is to continue this way, especially in IT security and IT criminal law.
So we as a community could probably support this process and help you as lawyers understand technology better.
Yeah, the lawyers, and then subsequently. Yeah, genau. It's the prosecutors who are more up to date, and especially the judges who will apply the law how it is. But we can update the law to make it more current.
So, any more final words from anyone? Final questions? Yes, there are two more. Great.
So you thought that the government invited people for the this law process. Who they invited and why and how to make part of this process?
Well, they invited, for example, Manuel Artuk, who was on the panel last year, or me, and other people who you can probably just Google us and find us. And then this is how, and then we recommend each other. So this is how we get invited. Oh, yeah, I can hear you.
So I just want to understand how to participate for that, because I would like to help, for example, I may be someone else here, because I'm working in security like more than 20 years. And I guess I could contribute with something. So if the process is like, I can apply, or, I don't know how to do that, or if only for invited people.
It's pretty transparent as it is right now. And yeah, by recommendation, this is still how it is right now.
Actually, they did something similar in Poland recently, like last month, but it was like very open. And I think they had like 200 people coming there or something like that. It was like a ridiculous amount. So everyone had like 2 minutes, and then if they didn't have time to even like, I think, listen to half of the people. So that will no, I didn't go there. But I had a bunch of friends going there.
Yeah. So
but that's one of the ends of the spectrum. If you invite too many people, then you won't be able to progress. But I don't know how to do it well.
Yeah, so how it usually works in Germany is that you have when new laws are made, you have this Verbändeanhörung. So organizations are asked to send people to these events, and there is a proper process for that. So find an organization that works in this area, and you might be able to get into these discussions.
Hello, my name is Ioan. I work for CyberLifeX, and we provide cybersecurity services for the automotive industry. And you mentioned earlier the Cybersecurity Resilience Act. But until then, what about company culture? What can we do? Can we do anything about it? What can we do there?
So actually, this was asked to NEVAC, the train manufacturer from our case. For example, because we had this working group in the parliament, because they got a question why they don't sign the software. Because it's completely unsigned, and the only protection for replacing software in a train is to just have physical access, which isn't well guarded. And you can just plug the cable and overwrite it. So they basically said it's not required from them. And the technology is tricky because it's like super old. But I think it was mostly that no one requires that from them, so they don't do it because it costs money.
Yeah, so I was asking the very same question, right, to our engineering team. So why are you not, doing more for security? And the answer is the customer didn't order it. If he doesn't order it, it's not budgeted. And if it's not budgeted, I don't have time for it, right? So I talked to the CISO of a customer and told them, why don't you increase the demands? And if you order a train, right in there, it should be secure. And he said, I tried, but in order to do that, I have to talk my purchasing department into putting that requirement there. And if we put the requirement in there, the train becomes more expensive. And we are in a competition with other train operators for the same train lines. And the cheapest operator wins the track. I tried to get it in there. I couldn't for commercial reasons. And there's only one answer. And the answer is level the playing field. If we have regulation, right? If by law everybody has to play by the same rules, then everybody has to put in security into their contracts. And everybody will have the same price increase for security. I mean, in the end, your ticket for the train will get more expensive, right? But you're getting security in return for that. And this is how it needs to be played. You can't fix it by company culture. That's too abstract a term.
Also, a bit similar thing with providing more transparency. One train operator in Poland tried to, they wanted to buy trains, but they required sharing source code from the main PLC, buying the train with the source code, and they got 0 offers. No one wanted to sell trains with source code. So if it's not required, then you have the problem that no one will really do this.
Okay, so thank you all for joining me on this panel. Thank you for all your questions, and I think we have a break now. So 20-minute break, and I hand over back to Adam.
Thank you. Great panel.